All right, now we're going to start the review of contract law. And as I usually tell my students, I've led a very fortunate life. One of the things I got to do was write a textbook for this course. And I had some fun doing it because I reviewed over the course of my teaching career numerous business law textbooks. And it was interesting to see how they all handled the concept of what was necessary in order to have a binding contract. The textbook that we used for years and years and years, Smythe, Silver and Eason, the Law and Business Administration in Canada, said there were 6 binding elements. Well, it was one of the first textbooks, and as the others came out, they had to do something different, something to distinguish their books from the others. And the same thing with online materials. And so on page 97 of the textbook, I talk about the binding elements of a contract. And one source said, well, there's offer, acceptance, consideration, and an intention to create legal relations, although the fourth one was a little fuzzy. Then there was another one that said offer and acceptance, and they combined that as one element. I don't know why. But then they had the second element as consideration, then capacity, and consent. Well, consent is like intention, I guess, and then they added a fifth, which was lawful purpose. Another one, very popular and excellent textbook, talked about one element, the first element being consensus. When you dug into it, though, it said consensus is there has to be an offer and an acceptance. So what they were doing is they were differentiating their textbook from the other. Then the second element was consideration. The third was intention to contract. And then the fourth was capacity and legality of object. The one that we used for years said there were 6 binding elements, and it seemed to really make the most sense. So on slide 32, I've got 6 blanks there. And when you look at this slide, you should really say to yourself, okay, can I remember what those 6 are? Because it was one of those concepts, really 2 things I wanted everyone to remember from BADM 107 was the 6 binding elements of a contract and how to set up signature lines correctly. So the 6 binding elements of the contract, obviously, number 1 is offer. Number 2 is acceptance. Number 3 is consideration. And number 4 is intention to create legal relations or intention to contract. Number 5 is capacity. And number 6 is legality of object. And so, bingo, I bring those up on slide 33. Well, okay, so we got the 6 binding elements of a contract, but then the question becomes, what about performance? What about delivery? Are they relevant elements of a contract? And no, they're not. To have a binding contract, you need those 6 elements. But delivery and performance is the carrying out of the contract rather than having the contract. So let me put it another way. I say I'll sell you my car for $7,000. You say, oh, okay, I'll buy it. Do we have a contract? Because I haven't given you the car, so I haven't performed yet. You haven't paid me, so you haven't performed yet. So obviously, no, we don't have a contract. Well, yeah, we do, okay? Because all those binding elements are there, and if you look at the list, nowhere on the list does it say number 7 is performance and number 8 is payment. And it makes logical sense when you think about the way we do business. If I said, I want to sell your products, but I don't have money to buy it. So what I'd like you to do is give me your products and I will pay you on 30, 60, 90-day terms, which is a very common thing. Well, okay, so you give me the product. If payment was really important to have a contract, then I haven't paid you, so we don't have a contract, so how do you get your goods back if I don't pay you? Okay, so obviously I've made an offer. I'll sell your products and pay you on 30, 60, 90-day terms. You say I accept, and you give me the product. I haven't paid you yet, but there is consideration there. No, there isn't. Yes, there is. My consideration is that you're giving me the product, and your consideration is that I will pay you on 30, 60, 90-day terms. We intend a contract. It's completely legal, and we have capacity. So bingo, You have a contract. I don't pay you. You can sue me. Okay? So obviously, those 6 binding elements are there whether performance and payment is delayed. Okay. Okay, so those are the binding elements of a contract. 6 ways that an offer can come to an end. It's my 6, okay? Other textbooks use different numbers. But what we're going to do is we're going to look at a number of ways offers can come to an end. One of the things I discuss in my textbook is that a lot of other authors say that obviously an offer comes to an end when the contract is complete. It's semantics, but I've got to take exception to that. So, I'll sell you my contract or your products on 30, 60, 90-day terms. Bingo, we have a contract. Performance. Well, you send me the product and I start selling it and it turns out it's defective and people are returning it and I'm having trouble replacing the money and I don't want to pay you the full amount. So if the contract was complete after you gave me the product, well, let's say I even paid you and then I'm selling your product. If the contract was complete and that offer comes to an end because the contract is complete, then how do I sue you? Because we don't have a contract. Okay, it's semantics. You probably just heard my daughter in the background. Breakfast is being served, so I'm going to put my video on hold right here and I'll come back. Yeah. All right, I'm back after that interruption. My apologies. One of the problems with the COVID-19 pandemic working from home thing is that other people in the house don't necessarily know when you're supposed to be in your office doing work. So I was interrupted by my daughter for breakfast, and I'm feeling good now because I had homemade pancakes from scratch by my wife, who's an excellent cook. But back to the material, we were just about to get into the ways that offers can come to an end. Now, the first thing you have to remember is we're not talking about contracts coming to an end. Contracts can, under certain extraordinary circumstances, come to an end. But usually when there's a contract, the courts are extremely reluctant to say, oh, that contract is over. No, we're ending that contract, and because then the whole contract system would break down if no one could feel confident that their contract was going to persist. So we're talking about offers here, and I have figured out that there's about 6 different ways that offers can come to an end, and you'll see on slide number 35 that there's a 7th one in brackets, and the reason it's in brackets is sometimes an offer is made, but it's so vague that it really doesn't amount to an offer at all. So does that offer come to an end, or did it not exist at the beginning? Again, it comes down to semantics. And so really there's 7 of them. On the exam, it's make a good Part B exam question. And if you put down vague offers, then I would accept that. Okay, the first way is someone makes you an offer and you say no. Okay, that offer is rejected. Can you come back later and say, oh yeah, by the way, I accept your offer. Well, in the meantime, the person that made the offer might have sold the item to somebody else, okay? So I'll sell you my car for $7,000. No, I don't want it. So I go off and sell it for $7,000 to somebody else, and you come back later and say, hey, I accept. Well, there's been an offer and an acceptance. Is there a contract? Well, obviously there shouldn't be, okay? Logically. And so rejection is one way that an offer can come to an end. An offer can also lapse. Some textbooks say there are 3 ways. I really think it's 2 ways, with the third that in that other textbook falling into my category number 4, but I'll deal with that in a minute. Lapse within a specified time. So I'll sell you my car, let me know by 5 o'clock Friday. 6 o'clock Saturday, you say, okay, I accept, I've already sold my car, have I sold it twice? No, obviously, because my offer lapsed at that time, 5 o'clock Friday. But then there's this really sticky situation where I don't say a time. I just say, I'll sell you my car, and you say, I'll think about it. Well, how long does that offer stay out there? 4 years later, you come, hey, Peter, I'll buy that car. And I go, what car? Who are you? and you say, oh, you made an offer and I'm accepting. Well, obviously that's ridiculous. But what about a week later, 2 weeks later, a month later? When does that offer sort of logically come to an end? And the courts take the attitude that it comes to an end after a reasonable period of time. The courts also go on in numerous situations to say what is reasonable is a question of fact, which means you look at the particular circumstances of that offer and you decide what's reasonable. So I'll sell you my car for $7,000. A week, 2 weeks, 3 weeks, a month might be considered reasonable, particularly in COVID-19 situation where a lot of people are trying to sell things because they need income because they're not working. So there's numerous cars for sale, and it's taking a long time. So they look and they say, well, it's not perishable, and what's the average time period that somebody sells a used car? And they decide what's reasonable. And if you do not want the court deciding what is reasonable and holding you to a contract, then you want to put in a time, specify a time that it comes to an end. Perishable goods, obviously the time is a lot shorter. I'll sell you 100 flats of peaches at $2 a flat, and you say, let me think about it, and you call back a week and a half later. Well, I've got, peaches that are starting to mold and go soft, and no, I don't. I've sold them already because I had to get rid of them quickly. They're perishable. So the reasonable time would be considerably shortened. Okay, so that's lapse within a reasonable period of time. Then the other one that some textbooks say is lapse when one of the parties becomes insane or dies. I don't think that's so much the offer lapsing as suddenly there's a lack of capacity. And that therefore voids any potential contract that might come out of it. And it sounds funny when someone dies or becomes insane, but there was a court case a long time ago, and I wish I'd kept a reference to it. There was a farmer who had bought a Studebaker Golden Hawk. What the heck is that? Well, if you go online, you'll find out that the Studebaker was a car made by Canada. We had a motor car company, and it made way better cars than the United States. But it went out of business. Why? Because the United States sold cars. Why? Because they would break down after a while, and people would want to replace them. The Studebaker lasted forever. I know my dad had one. So unfortunately, there was not the turnover necessary to keep the car company going. Towards the end, when things were looking bleak, they thought, well, we need to jazz up sales, so they came out with a Studebaker Golden Hawk, which was basically a Studebaker with big fins, and it was metallic gold. So now they had a really reliable, ugly car. And this farmer bought one. And I don't know, I guess maybe he was embarrassed that he bought it or something, because he put it in the garage or the barn on his farm, and he covered it with a tarp. His nephew would come out to the farm every so often and go in he'd take the tarp off, he'd sit in the car, boom, 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 and as he go older, boom, boom, boom. The next thing you know, he's driving it around the farmyard, and eventually the farmer got older, and he said, look, I want to sell the car, I'll sell it to you for $5,000. Kid goes, oh, wow, uncle, I'll have to see if I can come up with that kind of cash. So he goes away, and he's trying to raise the money, and the uncle dies. Everything goes into the estate, and the executive for the estate is going to sell the car, and the young lad turns up, and he says, no, he made me an offer, and I'm here to accept. Well, you can see that there's a potential problem here. and that is that the only person that knows that there was a valid offer made was the farmer, and he's dead. So to prevent frauds from being perpetrated, the law says if the person is insane or dies, the offer dies or is void. Okay. Otherwise, hey, my uncle's farm is worth $3 million, but he said he'd sell it to me for $28.95. And so to stop frauds like that, they say that the offer ends if the person becomes insane or dies. Okay, revocation. Selling my car for $7,000. Well, somebody else says, hey, Peter, I'll buy your car for $8,000. I want to sell it to them, so I sell it to them. And, 4 hours later, you come up to me, hey, Peter, I accept your offer. And I'll say, oh, I'm sorry. I will be sorry because I've now sold the one car twice. I sold it to the other person for $8,000, and I've now sold it to you for $7,000. I just don't have a car to give you. I'm bound to that contract, so you can sue me. Sue me for what? Well, okay, you looked at the condition of my car, the age of my car, the maintenance records and everything, and you decide that it's worth $7,000, or that $7,000 is a real bargain. You then go out and find a similar car, and it costs you $11,000. Well, you could have got mine for $7,000. Now you've paid $11,000, and the difference is $4,000. Okay, so you will be able to sue me for $4,000 because that is the damages that you have suffered. All right, so I don't want that to happen. So I say, I'll sell you my car for $7,000, and you say, let me think about it. And then somebody else says, I'll buy your car for $8,000, and I go, okay, I'll sell it to you for $8,000. Now, what I want to do is the next time I see you walking towards me down the street, I go, hey, Deborah, I revoke my offer. And you go, I'm sorry, what? I revoke my offer. Because then I've revoked my offer before you've accepted, and the offer is no longer available to be accepted. Counteroffer. I say, I'll sell you my car for $7,000. And you say, no, sorry, but I'll pay you $3,000 for it. Well, there's no way I'm going to sell it for $3,000, right? So I say no. And you say, well, okay, I'll buy it for $7,000 then. And now I'm irritated with you, okay, because you lowballed and made me a ridiculous offer. And I say no, and you say, well, no, you made an offer, and I've accepted. Well, the counteroffer extinguishes the original offer. Okay. In the car example, it doesn't happen too often like that, but let's say you're selling a house. Okay, so you list your house. What is that? Well, that's an invitation to do business. Okay. It's not an offer. You list your house, you want people to make you an offer. So they make an offer, and you reject that offer and you make a counteroffer. That counteroffer is no longer available to be accepted, or pardon me, my original offer is no longer to be accepted because that counteroffer extinguishes it. Okay? All right. The seventh one is a vague offer amounting to no offer at all. And this is a situation where somebody makes an offer and you accept, but the offer is so confusing that you start to have an argument with the person. And what happened was there was a Canadian case where someone said, I'll buy lot A from you and I'll lease lot B from you. And I will pay you by giving you half the crop. And the other person said, I accept. And then the first person said, no, I don't want to do this. And the person said, no, you made an offer and I've accepted. It went to court, and the judge said, oh, what we've got here is a real problem because he's going to buy lot A and he's going to lease lot B. He's going to give half the crop. Is that half the crop on lot A and lot B, or just on lot B that he's leasing? Or is it half the crop on lot A that he's buying. And is the purchase effective immediately, which means that this is a completed sale, or is it an agreement for sale where it will not become final and binding until the crop is given? And so there were too many variables that are left out of the offer, that the offer is too vague to amount to any offer at all. Okay, so does that offer come to an end, or did it just not exist to begin with? Semantics, who cares? We got our list of 7 ways that you have to take into account when you're trying to create contractual relations. All right, now. Okay. We're going to look at each individual element of a contract. And we start with offer. Not very much has to be said, except that it is a tentative offer made by one party, the offeror, to the other party on certain terms and conditions, which have to be satisfied. It's important to distinguish the offer from what's called an invitation to treat, because goods on a shelf with a price tag, or goods on a website with prices, are invitations for you to make offers. Okay, so if a business puts up a website like Future Shop did, which used to be an electronics store before they sold, they were one of the first to open up an on internet website to buy and sell, and so they put up all their goods for sale, and they put up MP3 players that were supposed to be $99.99, but they put it up at $9.99 by mistake. 6 people went online. Oh wow, what a good deal. They input their charge card information, they hit the button, and it says sold. And then Future Shop realized there was a problem, so they closed down the site. Hundreds of other people were trying to buy, and it wouldn't let them complete the transactions. So there were a number of lawsuits that followed that, because Future Shop said, no, that was a mistake. We're not giving you the MP3 players. And the judge's attitude was, well, okay, the goods on the website were an invitation to do business. The 6 people that went online and said, yes, I want that, and they input their information, and then the website says accepted. Well, there's been an offer and acceptance. Consideration is $9.99 going to you, and the MP3 player coming to me. Legal capacity, intention, the whole thing. So there was a binding contract. Those 6 people got their MP3 players for $9.99. The other people said, hey, I tried to buy, and the court said, yes, but that is, I tried to accept their offer, but they wouldn't let me. And the court said, no, that was an invitation to do business. You made them an offer. They do not accept. If they don't accept, then there's no contract. Okay, so that's the invitation to treat idea. It came from a case that we took in BADM 107, the Pharmaceutical Society of Great Britain versus Boots Cash Chemistry. The government of the UK passed a law that said certain prescription drugs had to be certain drugs in the store had to be sold under the supervision of a pharmacist. Okay, and they passed the law, and this well-meaning civil servant begins to skulk around the cities of London looking for people that are breaking the law. Goes into one of the pharmacies, Boots, and goes to the shelf, and he finds one of these prohibited drugs, and he takes it up to the counter, and he says, "Here's my 3 bob 6," or the English currency is, I don't understand it. But anyway, gives them, or puts the money in the counter, and the clerk says, "Oh, I'm sorry, I can't sell this to you. I have to get a pharmacist." And the guy goes, "Aha, gotcha!" He said, "You made the offer, and I've given you the money. The contract is complete. You've broken the law." He shoots out the door and comes back and has them charged with an offense. Judges are impartial, unbiased observers of fact. Meaning they don't come in with any preconceived notices or biases against race, religion, color, and creed. But we all have biases, okay? And you can see that the judge was, hey, wait a minute here, think this through. The whole point is to protect the consumer. Had the clerk said, well, I'm not supposed to sell this to you without the druggist being here, but he's busy, so what the hey? then the law would be broken. But the cashier said no. Okay, so the law was working. And so the judge wanted to find in favor of Boots Cast Chemistry, but had to put it into terms of offer, consideration, and etc. And so what he did was he said, well, obviously, past cases have indicated that goods are an invitation to do business. So here we had an invitation to do business, we had an offer, but the clerk said no, so there was no acceptance, the law wasn't broken. All right, so that's offer. And invitation to treat, as it's called in the United Kingdom. In Canada, it's called either invitation to treat, but usually it's an invitation to do business. Acceptance, must be communicated. It must be positive, and you cannot stipulate silence. I'm not going to say anything more about that. We did that in 107, so if you have to have any sort of explanation of that, you can get it out of the textbook. All right, so there's 3 types of contracts that result from offers and acceptances. One is a bilateral contract, where I promise to sell you my car for $7,000 and you promise to pay me. We have an exchange of promises. And the consideration doesn't have to be immediate. Okay, so I will perform later and you will pay later. We have a bilateral contract. But there are situations where there are unilateral contracts. A reward case where you say, I will reward you if you find my lost cat, $20 or something like that, and you put up notices around the neighborhood. People don't have to come and say, I've seen your offer for a reward, I'm now going to go out and look for your cat. The expectation is that the person will find the cat, bring the cat to you, and you will pay them $20. So I'm making an offer, and acceptance occurs by performance of the act. Now, that's, a reward case, and it's kind of, silly from a business point of view, but how about this? I have a website, and you can go on and you can order goods, and they will be delivered. Okay. Nobody says, we received your order online, we accept your order, we are now going to package it, we're going to deliver it, hang on. No. You send in the order, they send you the item. They perform by doing the act requested. I'm an amateur astronomer. There's a really neat item called LabCam, which comes with a place where you can put in your iPhone, and it has a eyepiece on it. You take it, you put it on your telescope, and you can take pictures. Well, I ordered from the company, and they sent it to me. For obvious reasons, they want to make sure, and so they did actually say, we've got your order, we're sending it to you, and then they gave me a tracking number. But they didn't come back. They didn't have to come back and say, we've got your order. They could have just sent it to me. All right, so that's unilateral contract. The problem with unilateral contracts is if you have to perform the act before you get paid, what happens if just before you're finished, I say I revoke my offer? Oh, you haven't completed yet, so you don't get paid, even though you might have done most of the work. The court, that happened in business a lot. People were taking advantage of other people, and so what the courts did is they invented a clause in your contract called a subsidiary promise. This is called an implied term. Okay, so I say to you, I will pay you a certain amount of money to trim my hedge. And I put out all the equipment. You turn up and you start doing it. You're just about done. I walk up and I say, I'm sorry, I'm revoking my offer. The courts don't like that. So what they do is they say, once that person has started to trim the hedge, one of the clauses that is in my contract, even though I didn't know about it, is a subsidiary promise that says they now have an opportunity to complete. If they do not complete, they do not get paid. And that happened to me where we used to live when we had the bed and breakfast in the Sunshine Coast. We had this huge, monstrous hedge. It was a fir tree hedge, and it was 18 feet high and about 14 feet across at the top. And I used to go up on this ladder, and I used to use this long pole, and I would be trimming it every year to keep our view. Got to the point where I couldn't do it, so I was asking various people, gardeners and tree trimmers and stuff, if they'll do it. Couldn't get anybody to do it. Along comes this guy and he says he'll do it. And he said he'd do it at a really ridiculous price. Low price. I actually said to him, no, think about this. Are you sure you can do it for that price? And he said, oh yeah, for sure. So I said, okay. And he starts, and he's done it for he's struggling for 6 hours one day. And finally, I sort of see him, and he disappears into the hedge because he fell. He comes back and he says, I'm not going to do it. Pay me for 6 hours. And I was really upset because I had spent a lot of time interviewing people, getting quotes, finally settling on this fellow. And now I had to go back and start it all over again. So I said, no, I'm not paying you. You said you would do it. You haven't done it. I'm not paying you. It's a unilateral contract. He was really quite upset about it. And so I said, okay, well, you said it would take so much time, and, you're not getting 6 hours worth because you haven't done any work to warrant that. And he was really mad, and he said he was going to sue. I went to university to teach. I came back the next day, threatened my wife if she didn't pay him. And you don't threaten my wife, okay? Lovely woman. Do not threaten her. So I think he went away frightened. But I did give him some money. I shouldn't have. Because then I had to go, and the hedge is growing, it's getting worse, I'm losing my view, and I've got to go and try to find somebody now that would do it and everything. But had I gone out when he was half done and said, stop working, I'm revoking my offer, the courts would have said, hey, there's a subsidiary promise that once he started, he has to finish, or has to have an opportunity to finish. I actually told the fellow that, I said, look, you're not getting paid unless you do it. You started, you can have an opportunity to finish, but he wouldn't do it. Okay, anyway, enough of that. Next item is consideration. I've just going to look at my textbook because I use a different definition of consideration than the previous textbook. Okay. No, I can't find it right now. Anyway, consideration is basically the exchange of benefit to both parties. So consideration for one party is the money that's going to be paid. Consideration for the other party is the thing that they're going to perform. We have to note a gratuitous promise here and distinguish that from consideration. A gratuitous promise is the promise made in the absence of one party receiving any consideration. So, I say, I'll sell you my car for $7,000, and you say, oh man, I'm a struggling student, I can't afford it. I say, okay, I'll give you my car. And you accept. Well, I've made an offer, and you've accepted, but there will not be a contract because consideration is not going both ways here. The consideration you're getting is you're getting my car. Wow. The consideration I'm getting is nothing. Okay. Except maybe that warm, fuzzy feeling in the pit of my stomach knowing I've helped a struggling student. Unfortunately, that's not recognized at law as adequate consideration. Now we're going to get into a topic under consideration called the use of a seal. I'm going to go into this a lot because seals are used numerous ways nowadays and is done so incorrectly in a lot of cases, and it causes problems when contracts are supposed to be performed. The concept of a seal came from ye old English days when people could not read and write, but they still had to enter into contracts, at least the well-to-do people. Okay, the peasants didn't own land, so it really didn't matter. But really, then there was only land. You couldn't invest on the stock market. You couldn't invest to sell goods through your retail operations because that was not as wide a factor in those days. Basically, land represented wealth. You had crops, you had fruits and vegetables, you had trees, and you could sell water and lumber and I don't know. Anyway, minerals, okay, all that sort of stuff. So contracts concerning land were very important. And so when I wanted to buy property but I couldn't read or write, I would have someone draft the contract that I could trust. They would read it to me, they would read it to you, and then they would have signature lines and we would put an X on there. Why? Because we can't write, all right? The problem with that is a couple of years later, if there was a dispute over the ownership of the property, one X looks pretty much like another X, and there was all sorts of problems in court proving the signatures. When I was at law school, we looked at this really old case where this fellow was buying property, and he was going to put his X on there. And so he turned to his son and he said, I want you to remember that the X at the top of this document right here is mine. The typical kid goes, yeah, right, Dad. And he says, no, I really want you to remember. And the kid goes, yeah, right. The father says, I want you to remember. Picks up a piece of wood, hits his son in the side of the head. What did you do that for? He said, because I want you to remember this date, and that's my signature. A couple of years later, there's a dispute. They're in court. And the judge says, well, Mr. So-and-so, how do you know that's your ex? And he says, well, I know that that's my ex, and I have proof. And the judge went, oh, really? He said, yes, my son. The son gets on the stand. The judge says, how do you know that's your father's ex? And the son gets on the stand. He says, that is my father's ex. And the judge says, how can you be so certain? And the son goes, see that scar on my head? My father hit me with a piece of wood so that I would remember. The judge says, okay, that's good proof. The problem is we cannot go around, hitting people on the side of the head every time we want them to remember a contractual obligation was performed. And so the custom became that you would put your X there and then you would drip some wax beside your X, and everybody in England that was wealthy and owned land would have a coat of arms, okay, and a signet ring, or either their coat of arms on a little stick, and they would go psh, and they would emboss the contract with the wax and the impression of their seal. And this became a very significant act with respect to land. You are the covenantor. It's considered to be a covenant. And then eventually, as business expanded, the document became known as a deed. Okay. The act became so significant. Well, let's look at slide number 38, which is the Magna Carta, and it showed the ribbon with the lead seal of the king embossed on it and held in place. Same thing on slide 39, where you can see the Pope's seal at the bottom of the papal bull that discharged the Magna Carta. Eventually it became wax on a document with the coat of arms embossed in it. And I want to step back a bit and talk about my family seal. I will try to get to the university. I live on the Sunshine Coast. I will try to get to the university, and I will bring home a copy of my family crest and some other materials related to seals so that we can complete this, but I'll deal with it just verbally now. I had my father, when I turned 16, I guess, my father took me to a heraldry shop, and we traced the Holland family name. Well, they only went back so far, and I got this wonderful plaque which showed a shield, for battle, and on that shield there was 3 capes, like Zorro with a cape, or Batman. Anyway, the capes were in the shape of scallop shells, and it was red. 3 was really significant to me at that point, because in our family there were 3 children, in my dad's family there were 3 children, and in my dad's family there were 3 children. So I thought, 3 is significant. Well, later on, my uncle went back to England and traced our ancestral tree all the way back to our ancestral castle. Well, okay, it wasn't really a castle so much as a manor. Okay, it wasn't so much a manor as a cottage. All right. It was a cottage with a dirt floor. I am not in line for the throne, okay? Anyway, I'm just joking. He traced our family tree back to the real shield, which was a different shape, and it had some, red lines on it, and it had a mailed fist. What's a mailed fist? That's an armored fist. That was even better than the capes for a lawyer. An armored fist. With the whole Holden family line, our motto for the family was neither timidly nor rashly, which in those days meant I'll kill you, but I won't do it with anger. Okay. Nowadays it means I'll sue you, but I won't do it with anger. Just kidding. Anyway, that was our motto. And I found that really interesting. I thought, okay, Irish on one side, or English on one side and Irish on the other. I'll check the Irish side. That is so confusing. The Irish family trees are just bizarre. Anyway, I went back. McCormick is the Irish name, and I went back and back and back, and I couldn't make heads or tail out of which seal actually belonged to my family. But I was interested to find out that the motto for McCormick was neither rashly nor timidly. Is that awesome or what? It's like the Twilight Zone. Anyway, back to seals. So that mailed fist, or those 3 capes on that shield, would be my logo, my family crest, which would be on a signet ring if we were rich, or on a piece of wood if we were poor. And I would sign a document and I'd put wax on it. Well, looking at slide 40, it's red. Why red? Well, back when they had to do this with wax, they needed wax that was readily available. And there was red and white wax readily available. Why? Because of the church. White for the purity of Christ and red for the blood of Christ. And so they tried using the white, but it was translucent, and so the crest wouldn't show up. They used the red because it had dye in it, and the crest would show up. So the custom became red. Use red. And I have examples of what they use today, because I look around my classes and I ask people, how many people have their family seals on their signet ring or on a separate seal, and very few people even know what their crests look like. So, but documents still have to be signed under seal, and so what we have to do is we have to use something nowadays. And I meant to bring it in, I didn't, so I'm just going to stop here very briefly, and I'll get a sample of the seals. Okay, the seals that we use nowadays, other than corporate seals, which I'll show you later, are just what they call red wafers. And all you do is you peel off one of those little red sticky things and you put it beside the signature line on a document. As I mentioned, this became such a significant action that eventually the need for consideration was eliminated. So I could sign a document. I'm not receiving any consideration, but if I signed under seal, I was bound with the document. Okay, it was called my act and deed. And there have been some significant cases related to that. One of the most significant one was at the bottom of the slide 40. It says the Royal Bank versus Kiska. A fellow by the name of Kiska has a hairdressing shop, and it's not doing very well. Okay, and so the bank says, listen, we need some security, or we're going to have to take action against you. So he said, well, I don't have any assets, but my brother runs a little pizza shop, and he will provide maybe a guarantee. So they bring in the brother, and the brother says, I don't really understand what this document's all about. And the bank said, well, you sign here, and what that means is that if your brother cannot pay his loan through the hairdressing shop, then you'll have to pay. And he goes, oh, well, is this likely to happen? And the bank said, oh, no, it's very unlikely that it'll happen, but this is just, further security for us. So he signs. And there was supposed to be a seal on the document, but there wasn't. He goes away. The other brother's business, the hairdressing shop, fails. The bank calls him in and say, okay, you're going to have to pay. And they show him, he says, well, I don't know why. And they show him the guarantee, and now they've put a red seal on it. And the young lad is just absolutely, totally distraught. And they say, he says, like, what's the deal with this red seal? And they say, well, that makes you, legally bound to the document. So he grabs the document from the fellow in the bank, starts ripping it up, and starts trying to eat the part with his signature and seal. And the bank people are trying to stop him, and they call in the security, and they spit it out, but it's destroyed. So with the security guard there, they make him sign another one with the seal on it. Okay. And then they go after him for the money, and he refuses to pay, and they get into court. It goes to the Court of Appeal. So there's 3 judges sitting. 2 of the judges say the seal was not on the contract of guarantee at the time it was signed, which would usually make it invalid. However, that's irrelevant because there was consideration. Okay, the bank's consideration is that Kiska agrees to pay. What's Kiska getting? Well, the bank said, the judge said that the lawyers for the bank put forward the case that the bank said they would forego suing. So the forbearance was the bank's consideration, or the Kiska's consideration, and the bank's consideration is that Kiska's going to pay. And so they held the contract valid. The 3rd judge, Justice Laskin, went on to become a Supreme Court judge, probably one of the best judges Canada's ever had. He wrote a dissenting opinion, which has since become the real law on guarantees. What he said was, I disagree with my brother judges because the document that he signed did not say that they were forbearing the lawsuit. So there was no forbearance. As a matter of fact, the document said that there was no restriction on them taking action at any time on the guarantee. He said, so the forbearance wasn't part of the contract. It was reduced to writing. That's extraneous, right? And so he said that contract, he was receiving no consideration. The seal wasn't on it. Therefore, it's not binding. Okay. Well, Kiska lost because 2 judges, the decision is that he has to pay. However, over the years, that Court of Appeal decision has not been really used. The dissenting opinion of Laskin, however, was used. In a case in British Columbia on enforcing a guarantee, the judge said that the dissenting opinion in his consideration is correct and really properly outlines the law. And so he followed the dissenting opinion. Why didn't he overrule the Court of Appeal decision? Well, a lower court judge cannot overrule a higher. That's not true. He could have said, I'm overruling the case, but you cannot overrule the law of another jurisdiction. Okay. So he just followed the dissenting opinion, which he thought made better law. And so on slide 41, I've outlined some basic lessons that we learned from the Kiska decision. Just for clarity purposes, I am going to read them so that I don't get them wrong. The general rule is that in the absence of consideration, seals must be affixed to a contract at the time or before the contract is signed to bind a third party to the promise. Third party, what do they mean by third party? Here's the Kiska that had the shop, the hairdresser shop. Here's the bank. The contract is there. Okay. Here's the younger brother Kiska. He's not a party to that contract. So by signing this guarantee, he's considered to be a third party to it. Okay. All right. So the general rule, seal has to be on at the time or before the contract is signed. If the seal is not affixed, the contract will not be binding unless the court can establish consideration in some other manner, such as forbearance. Okay. The other rule, it is not necessary for the seal to be a red wafer. It would be nice if it is, but you can do something to indicate your intention. Okay, so, oh, wait, sign this. Yeah, sign under seal. Has anybody got a seal? Anybody got a seal? No, I don't have a seal. Do you have a seal? No, I don't have a seal. So what do? Well, you can write sealed and circle it, or just write sealed and underline it, or use a yellow crayon and, or whatever. Okay, something significant, all right? Some guarantees generally come with a printed form, and on the printed form it'll say affix seal here or affix seal, or there might just be a bracket that says seal. Well, you sign. Does the fact that it says affix seal mean that you signed under seal? No. The rule is that that just shows that the signer's intention to sign under seal, but not merely, it does not show their intention to sign under seal. It merely means there's formalities that have to be taken care of. Okay, so the seal has to be affixed. The recital signed on sealed or there are some recitals on contracts that say signed, sealed, and delivered. And I think it might be in the contract assignment that you have to do for this course on the precedent that I give you. I'm not sure. But anyway, some say that. And others say, whereunto we have affixed our seals. Again, Laskin's decision means that it does not mean the document is sealed if nothing is affixed. Okay. One other interesting note that I wanted to bring forward is that I said you had to do something significant to indicate your intention to sign under seal. What about taking your thumbprint and putting it on there? This happened in the Wolf versus Oliver case on slide 42 in 1967. And the judge in that case said, Wolf didn't say, or Oliver didn't say, I'm sealing the document with my thumb. He just, put his thumbprint on there, and the other side said, hey, that's a seal. And the judge said, no, it means he's identifying his signature as being his. So there has to be something. He has to say, I'm sealing it. Okay, and there has to be proof of that. Or he has to say that to the judge, and the judge has to believe him. So that's kind of an interesting case. Now, corporations sign under seal. They can do their corporations pursuant to Section 30 of our BC Business Corporations Act have all the powers and capacities of a natural person. Okay, so they should be able to sign documents under seal. There are differences between jurisdictions here, though, and you have to be a little careful because in British Columbia, for example, Section 193 of the BC Business Corporations Act says a contract that would by law be required to be in writing and under seal may be made for a company in writing and under seal in the same manner. Well, that just means that all those requirements from the Kiska case have to be taken care of, whether it's a person signing or whether a corporation is signing. Look at Saskatchewan, for example, in Section 23 of their Business Corporation Act says an instrument or agreement executed on behalf of a corporation by a director or an officer or an agent is not invalid merely because a corporate seal is not affixed thereto. Aha! So you have to be a little careful when you're dealing with different legal entities. One anecdote. You have to do something significant to indicate your intention to sign under seal. I had a really good client, owned an advertising agency, and he became a close friend over the years. And his name was Cam, and Cam sold that business, and he wanted to go into another business. And there were going to be 4 people involved. Now, I knew Cam really well, but I didn't know the other 3. They were going to form a corporation, and they wanted a shareholders agreement. A shareholders agreement, the parties should sign under seal. Why? Because you're setting up a corporation that's going to do stuff, sell stuff, buy stuff, whatever. But at the time you set up the corporation, you're signing this shareholders agreement, which is just a contract. But what consideration are you getting? You put at the beginning in consideration hereof, which the parties accept as, adequate. That's not going to save you. But so you want to sign under seal. And so you're bound to the contract even in the absence of receiving any consideration. Well, Cam says, we're entering this contract or corporation, and I want you to draft us a shareholders agreement. So I drafted the agreement. We, did some back and forth amendments and things. I'm lecturing at Capilano University, and my cell phone goes off. So I apologize to the students, and I pull out my cell phone, and I go, hi. Oh, hi, Cam. Or no, pardon me, it was my wife, and who's my business manager for my law firm, right? And she says, Cam says that the 4 of them are together. They've reviewed the shareholders agreement. It's signed. The draft. It's perfect. They want to sign it while they're all together. So I said, okay, quickly make up 5 originals. Why 5 when there's 4 of them? Well, the corporation is a separate legal entity, right? So all 5 of them are going to sign. The corporation and the 4 individuals. And I said, courier over them, but remember to put seals beside the names of the individuals. Well, my wife goes, oh yeah, okay, sure. And she, I got to back up a little bit. She likes seals, like the seals in the water. We used to have a cottage in the States on the Hood Canal. There used to be lots of seals. She'd go swimming with them, and they would actually play with her in the water. So one Christmas, I gave her a sheet of stickies, but not red ones, little pictures of seals. And she thought, oh, this is funny. So she takes those little seals, or seals, and puts them on the documents, and couriers them over to the client. I'm lecturing about blah, 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 blah. And my cell phone goes off, and I answer it. And this time it's Cam. And he's laughing, and he's saying, ha ha, I got the document, ha ha, the seals, that's really funny. And I don't know. And so I go, no. Those seals are really important because they indicate, I'm going to a long explanation about no consideration, bind the contract. And he's laughing and he says, "You don't know, do you?" And I go, "What?" And he tells me that my wife put little pictures of seals beside their names. I mean, okay, fine with Cam because he's a close friend, but these other three business people don't know me, and they think this has got to be one of the weirdest lawyers on the face of the planet Earth. But I launched into an explanation following that by saying, well, you can have a document signed under seal not having to put red seals on, as long as you do something that indicates your intention to be bound under seal, and what could be more appropriate than little pictures of seals. I was trying to save myself. Anyway, he has long since stopped business. Unfortunately, he passed away because he smoked. So if anybody here smokes, those things will kill you. Okay? Oh no, not me. It'll be my other friends that die from cigarette smoke. Don't believe it. Okay. My brother-in-law passed away from cancer of the throat because of smoking. My really good friend passed away from cancer because of smoking, so just don't. Anyway, I'm getting down off my soapbox. Anyway, I tried to save myself, but he wasn't taking any notice of it. He's now passed away. The business has long since stopped. It's well over 15 years ago, so I've shredded the file. I should have kept them. Anyway, as long as you do something significant to indicate your intention to be bound under seal, it will be considered a seal. All right, that's enough on that. You can almost bet that that topic will be on the exam because I've spent so much time on it. Okay, to finish off consideration, we have to talk about the adequacy of consideration. The courts are not concerned with whether you've done a good bargain or a bad bargain, as long as there's a bargain there. Okay, so that's why in a document you can say for the sum of $1 and other consideration, the adequacy and receipt of which is hereby acknowledged, that $1 will be sufficient. Past consideration is no consideration at all. Really quick example of this, if you don't remember this, is that you are going to go on a river rafting expedition and you go to the company and they tell you what's involved and here's the money and you pay and everything. That's great. You've paid. The contract is complete. You then go on the river rafting expedition and they say, oh, and by the way, we want you to sign this waiver of liability that you will not sue us even if we injure you through our negligence, and you sign. Well, you've paid, right? Your consideration is you're going on the trip, and their consideration is they're giving you the trip. So that waiver is binding, correct? Wrong. It's past consideration. You've already paid. The contract is complete. Then they run up and, oh, by the way, as part of that contract, we want you to sign this. No, that past consideration cannot be consideration to bind you to the contract of waiver. So that's why the waivers have to have seals. And one of the companies that I was doing work for said, do we have to put a red seal on when it's signed? And I said, well, yeah. And they said, what if we photocopy the form and there's a black dot there? And I thought, well, that would be sufficient to indicate that it was signed under seal. But going back to the Kiska case, I think somewhere I read that the photocopied form with a black dot on there, and then the person signs, the black dot would be like saying affix seal here. Okay, so I think you have to actually go through the formalities if you want the formalities to protect you. The safest way, and from a risk management perspective, is you say, okay, pay for the trip, and by the way, you will be expected to sign a waiver as part of the consideration. Okay, and you put it on your website. All participants will be required to sign a waiver. And then they're aware of it at the outset. Then it becomes incorporated as part of the contract. But if you try to do it separately, it will not protect you, which was the Delaney versus Cascade River rafting, I think, court decision, where a person paid for the trip. They took him in a bus way up into the wilderness. They're going to get on the raft. They're going to go river rafting. And they say, here, sign a waiver. And he said, well, I don't like this. And they said, well, you sign it or you don't go. He said, well, if I don't go? He says, we're out in the wilderness. The buses have already gone back. And they go, well, it's up to you. Well, he had no alternative but to sign. So he signed it. Unfortunately, he was killed on the river, and the waiver was held to be invalid, because of past consideration. All right, so next topic, intention to create legal relations. Two things here, non-arm's length transactions, arm's length transactions. Non-arm's length transactions, contracts between family and friends, close friends. The presumption by the courts is that you did not intend to enter into a contract on which you could sue or be sued. That was Balfour versus Balfour was a contract between a husband and wife. It was held to be invalid. And Jones versus Padavatten was a situation between a parent and a child. Okay, now close friends, same presumption. I have not been able to find a court case that substantiates that, but it's really doesn't happen very often anyway. But just be cognizant that seems to be the rule of law, although I don't have a case to prove it. If you want to have a contract between family members and you want it to be enforceable, then you have to take care of the formalities. You have to in some way signify to the judge that you want this to be a contract on which you can sue or be sued. I remember one time my brother-in-law from my wife's side, I can't remember. Anyway, my brother-in-law from my wife's side of the family called up and he said he wanted to lend money to his niece to buy a house. And he didn't want the banks to know about it because they were going to use this money as their down payment, and then the banks were going to give them a mortgage. The banks would be in the first mortgage position, but if the bank knew about this other money, then they wouldn't give them a mortgage because then it was 100% mortgaged house. Bit inappropriate, but both my niece and her husband had jobs where they were making money hand over fist. So there really wasn't a lot of risk. However, my brother-in-law said, what happens if for some reason they lose their jobs and the bank forecloses and there's equity in the house? I want to be protected. And they said, well, what you do is you get a mortgage executed in registrable form and you hold on to it. If they lose their jobs, then you file it as a second mortgage. Okay. Up until then, it's perfectly legal because only the bank is protected on title. But that was between relatives, and so they had to make sure that the mortgage document was formal and that it was executed in registrable form before a lawyer, the whole 9 yards, and then it would be enforceable. Okay. Arm's length agreements between business people or people that don't know each other. Okay. The question is, was there an intention to create legal relations? And 3 cases are listed on slide 46, which shows the way courts handle it. One, an American court, which for a long time had been used as precedent in Canada. Then there was the English court case that they decided to use instead. And then eventually Canada, or at least British Columbia, has its own case. Pardon me. Higgins versus Lissig, the position that the court takes is that the judge puts himself there watching an exchange between 2 people. And what happened in that case was there was a farmhand who, a farmer who had a number of farmhands, and I thought he treated them pretty well. So he was really upset one day when one of the farmhands had stolen a bridle. And he slams his fist on the table and he says, "I'd pay $100 to the man who points out the thief." Well, the only person that was there at the time was Higgins. And Higgins says, "Well, I know it was Bob." I don't know whether it was Bob or not, but that'll do. It was Bob. And so they go to the bunkhouse, and Bob has hidden the bridle under his mattress in the bunkhouse. Not the brightest bulb in the string. Anyway, they catch Bob. He goes off to jail. Higgins goes back and he says, "Okay, I want my $100. And Lissig said, "What, are you kidding? Do you think I was serious? The bridle's only worth $15. I was just upset." Pardon me, allergies. Higgins says, "You made an offer. I accept it. I want my $100. In those days, $100 was a lot of money. You go to court and the judge says, "Okay, Lissig's there. Higgins is there. Nobody else is there except Bob. Bob's in jail, not a very good witness. How do I decide whose story is the most believable here?" Not that somebody was lying, but he looks at the veracity of the testimony, like who is the most believable, who has the best recollection. And he said, "So what I have to do is I have to pretend that I was leaning against the bunkhouse wall and I saw Lissig make that exclamation and I saw Higgins say, 'I accept.' Would I think that that was a bona fide offer, or would I think it was the exaggerated exclamation of an excited man?" Okay, and obviously the judge said, is obviously not a serious offer. It's like when you say, "If I get my hands on him, I'm going to kill him." Well, did you really mean it? No, right? Otherwise, we wouldn't have a population problem in the world, because everybody says that at some point. So that's the way the Americans look at it. The judge looks, what did they intend? In England, in the case of Carlisle versus Carbolic Smokeball, case which we dealt with in BADM 107 quite a bit, the judge said, what would the average person on the Clapham Omnibus think? The Clapham Omnibus was a bus that went from downtown England to Clapham and back. Okay, what would the average man think if they saw that? Okay, not the judge, but the average man. Well, in Canada, another one of our really, really good judges, Madam Justice McLaughlin, who was a Supreme Court judge in BC, and I think from there she went to the Supreme Court of Canada. Fantastic judge, great decisions. In the case of Osorio versus Cardona, she said, and I'm just going to read it off the screen, what would the reasonable promisee believe the promisor intended? And I went, whoa, that can't be right, because what would the reasonable promisor mean? Well, Higgins was the promisor, or promisee rather. So what would Higgins have thought? Well, obviously Higgins thought that Lissig was serious. And I thought, no, that can't be right. So I thought, no, and I went back and I read the case, and suddenly it dawned on me that she wasn't saying, what would what would Higgins think? She was saying, what would the reasonable person in Higgins' position think? So the situation is the same. It's just different perspectives, but they all come down to, was it an exaggerated exclamation or was it a bona fide offer? All right, a non-arm's length gift is not taxable. So a family member gives a gift to another family member, no tax consequences. But there will be a deemed disposition at fair market value for an arm's length gift. Okay, so if I decided to give a business person a gift, the presumption is that you're going to be taxed at it, and if you're not taxed at it, then it was probably intended to be some sort of a bribe. All right, now another interruption. This is terrible, but I see that my battery is low, so I am going to stop here and go and find my battery and put it in. All right, another interruption, but I'm back. Plugged in, got the power. Let's keep going. Um, so we are now getting into capacity to contract, and what I'm going to say is read the textbook. There are numerous groups who are under a limited capacity to contract. Doesn't mean they can't contract. It just means they are under some sort of restriction. And there were 6 that I listed. Minors, which are people under the age of 19, people that are insane or intoxicated, incapacitated by drugs or drink, corporations, unions, enemy aliens, and bankrupt debtors. For the purposes of BADM 307, that's all I'm going to say, and you're unlikely to be tested on it to any great extent on the exam. Legality of objects. Contracts can either be void at common law or at statute, or they can be illegal. Okay, so a contract that is void would be one where, for example, I hire you, but I don't want to pay you EI or WCB payments for you, so I say you have to take care of those yourselves. Well, that part of our contract of employment would be void because you cannot contract out from under workers' compensation or EI. So that's a contract that was void by statute. A contract that is void under common law would be one where I hire you and I pull you away from a job that you are already at. In other words, I say, hey, I want you, I'll pay you more, quit working for them and come to work for me. Well, that is a tort, okay? Interference with contractual arrangements. You have a contract with that business, so that unless you quit by giving them the exact right amount of notice and come to work for me, you will be breaching that contract. So my contract with you will be void at common law because it's formed through an illegal action. So you've been working for that other company for 9 years. You're in a managerial position. I want your expertise. I want you to bring the customer list or the pricing structure or something, and I need you. And so I say, okay, I'll pay you $40,000 a year more. And you go, wow, all right, I quit. I give 2 weeks notice because you think, hey, 2 weeks, that's all I have to give. Well, if you've been working in a managerial position with that company, if you remember employment law, the expectation would be somewhere around 9 months notice. So you have to give them 9 months notice that you're quitting. I'm going to wait 9 months. I don't want to wait 9 months, okay? And so you quit earlier and you come to work for me. You've breached that contract. So my contract with you will be void because it's based on your breach of contract. Contracts illegal are more serious. You can be fined or perhaps imprisoned, depending, but usually just fined. It's like two businesses getting together and saying, I'll be in BC, you be in Alberta. Rather than compete against each other, let's have high prices and really screw the consumer. Well, that's abuse of competition policy under the Competition Act, and you can be, and the courts will express their positive disapproval, which means they'll fine you. That's all I'm going to say. The one thing that I do want to deal with, though, under this whole concept of contracts that might be considered illegal or void, is the concept of restrictive covenants. And this generally comes up in 3 scenarios where a vendor of a business is asked to sign a restrictive covenant saying that they will not compete against the purchaser for a reasonable period of time. And then also a situation between an employer and employee You're not likely to want to hire an employee, train them with some special proprietary information that you have, and then have them go across the street and compete against you. So you can put in a restrictive covenant preventing them from doing that for a reasonable period of time. And then there was the third one, the ones where we talked about businesses that decide to restrict competition by entering into a contract. These clauses in these contracts are called restrictive covenants, and they're defined on slide 50 as a term of contract which the courts presume to be prima facie void as restricting competition. Pardon me. Well, there are legitimate reasons why you might want to restrict competition in that instance. Because I'm, for example, a business owner and I want to sell my business to you, but you don't want me to compete against you. So you really have two options. You can buy my assets. If I'm selling my law firm, for example, you can buy my computers, which are used. You can buy my filing cabinets, my chairs, and my desks, but that isn't what you want. You want my customers. But if I get more money than my assets are worth because I'm selling you my goodwill, what happens if you pay me all that money and then I open up next door to you? Okay, and so the courts have a process that they go through to deal with these situations, and that is outlined on slides 51 and 52. First of all, the first step is they look at a contract with a restrictive covenant and they say it's prima facie void because it restricts competition. Prima facie means on the face of it, at first glance, at first blush. So in other words, we look at this, it restricts competition, it's void, unless you can tell me that there's a legitimate business reason why that clause should be valid. This is called the rebuttable presumption. So you then explain, well, I want his customer base, but and I'm not going to pay him for it unless he agrees not to compete against me with those customers for a certain period of time. So, and I go, yeah, and I won't be able to sell anything but my assets unless I give this restrictive covenant. So I've worked all my life and I've built up this goodwill, and it's worthless unless I do this. And so the judge says, oh, okay, that sounds reasonable. And then the judge says, okay, there's a third situation or consideration, and that is there a public policy reason why this clause should be considered prima facie void? And that would have to do something with national security or military use of the proprietary information, that sort of thing. And so there's a public policy reason. If there's a public policy reason why it should be void, it's void. There's nothing you can do about it. But in the absence of a public policy reason, and you've rebutted the presumption, then they go to the last step and they say, okay, the clause that we're looking at, the restrictive covenant, is it reasonable with respect to time, area covered, and the nature of the business? So, time. I use the dentist example because it's a really good one. You're supposed to go to a dentist twice a year. So, a reasonable period of time for a restrictive covenant on a dentist would be 2 years. Because if I'm a patient of yours and I have come to you 4 times and I cannot stand you, I come out, my mouth is always sore, it's terrible, I should be able to go back to my original dentist. All right, the dentist works in North Vancouver. So North Vancouver, city of North Vancouver, a reasonable area. West Vancouver, you'd have to establish that a lot of your patients come from West Vancouver before the area could expand. You certainly could not say Lower Mainland because none of the original patients came from Surrey or Richmond or Vancouver proper or Burnaby or whatever. So the area covered would have to be very specific. And it depends on the nature of the business. And then the last one is the nature of the business covered. So, for example, a dentist, you could say general dentistry, okay, which means I could then turn around and open up a shop next to you if I was going to do orthodontics, because orthodontics, I think, makes the crowns and things. So the dentist says, okay, you need a crown. They come to me. I give them a crown fit for that tooth. Well, I'm a supplier. Okay, I'm not a competitor. So you'd have to say dentistry. And that, if you just said anything to do with dentistry, well, I wouldn't be able to teach dentistry at the new faculty of dentistry opened up at Kaplan University, and there isn't one. I'm just pretending. Okay, so you have a situation where the nature of the business has to be restricted to the what the person was doing beforehand. Okay, and that concludes contracts. We are going to go into sole proprietorships, partnerships, and corporations in a big way, by way of review. Just before we do that, though, there is going to be one more short video, and that's going to deal with an update of an employment law situation. In BADM 307, we don't go into employment law. In BADM 107, we did, and we did in a big way because it was so incredibly important. And BADM 307, we do not do that. But between the time of my setting up the overheads for my BADM 107 and this year, I came across something that happened in the employment law very recently, and I think it's really important for businesses to know that. So we'll do a little short update on employment law, and that's all on this video. So thank you very much, and I apologize again for all the interruptions, but they're over, and on to our next one.